Charles Schwab Investment Management. He has the managing director at Charles Schwab. He has over 35 years of experience in the global financial industry in the areas of compliance, risk management, banking, and worked at legal companies such as Brown Brothers, Harriman, Wellington Management Company, and Charles Schwab. And he has earned his Juris Doctor from Suffolk University Law School, has a master's from Lindenwood University and a BA from Bates College, and he also holds the FINRA Series 7 license. So Michael, I would like to welcome you. Thank you for joining us. And tonight, Michael will present, will make a presentation about conflicts of interest, and we're very excited to see the presentation. And we will collect. You guys can post any questions that you might have to Professor Hogan, and at the end I'll bring them up so he can address them individually at the end. Okay, Michael, the stage is yours, and have a nice presentation.
Thank you very much, Francisco. First, I'd like to thank you and Alfredo for the opportunity to be here and to speak a little about conflicts of interest. I'm going to start by sharing my screen. All right. So, I've called this conflicts of interest a deep dive. It really is a representation and a categorization of observations I've had in my 35 years of experience in the financial services industry. To set a little context here for the agenda, I'll start by setting some context, for the discussion. We'll follow that with some definitions. No discussion is ever complete in the space of compliance and legal without definitions. So we'll explore those, which I think are helpful in understanding the concept here. We'll talk a little about the key parties that are involved, and then key characteristics that we can typically extract from these types of relationships. We'll identify some common relationships with inherent conflicts. Implicit in this notion is the idea that there are certain relationships that by their very nature entail conflicts of interest. And we'll talk about the importance of identifying them and doing something about them. The best way to see these, in my view, in action is really to look at a couple of examples. And so we'll do case study 1, the Enron situation, case study 2, banking crisis of 2008-2009. Each of these will give us very specific and clear examples of how conflicts come into play in relationships. And then finally, we'll talk a little about mitigations, and then I'll conclude with some observations on why all of this is so important to compliance programs and what compliance programs specifically can bring to the table with regard to conflicts. So by way of context, I think it's a natural observation to note that different interests are a natural part of business relationships. Many relationships, not just business relationships, involve different interests of parties. Let's consider two situations. Two farmers growing different products. Each needs what the other has to feed her family, and they swap based upon agreed upon value. This is a pretty straightforward arrangement. They both have needs, they both have families, they both have a product. And really, what they want is to exchange the product for the other. It's pretty straightforward. They're both acting in the interests of themselves and their families. And there probably, is little opportunity for what we call conflict here. Consider this other situation, though. Two farmers who grow the same crop. One travels around selling through local farmers markets, but the other sells his crops exclusively through the local farmers co-op. Now, in this situation, the farmer who is acting on his own, selling his own crops, obviously is going to try to get the highest price he can. The one who goes through the farmer's co-op, though, is really agreeing that his interest is going to be aligned with those in the co-op. He no longer can make decisions on his own, but he has to take into account the interests of the others. And so that type of situation creates this circumstance for potential conflict. And I point these out to show that we've all been in similar circumstances at some point in our lives and in our careers. I'm talking here about business relationships, but I think human relationships by their nature can involve these types of conflicts. That's reason for us to care. You know, I think some people may say, why should we care about conflicts of interest? Well, we should care because conflicts exist at the intersection of economics, human behavior, and human psychology. And for that reason, they're essential to understanding the motivations behind why people do what they do. It also, in many ways, ties into a broader concept of ethics and responsibility for others. I won't dwell too much on that because that can, bring us down a path more of philosophy and legal responsibility for each other. But I think it's important to note that as a background and as a framework, these interrelationships and how people make decisions becomes extremely important in the business context. I'll address here just a couple of definitions. So the topic we're addressing is conflicts of interest. We can break that down into these smaller pieces. Interest. Interest has been identified as a right, title, or legal share in something. Alternatively, a participation in advantage and responsibility. Each of these conveys a notion of benefit, if you will, to the person who possesses the interest, and potentially responsibility to others. Both very important concepts to keep in mind. Conflict, on the other hand, can imply mental struggle resulting from incompatible or opposing needs, drives, wishes, or internal and external demands. So conflict introduces the notion of potential discrepancies, of potential different interests that converge and that require some type of resolution. When we bring these together, we have conflict of interest, a situation in which a person has a duty to more than one person or organization, but cannot do justice to the actual or potentially adverse interests of both parties. Now, in a conflict of interest, one of those parties is typically the person, him or herself. And we'll see how that translates in business contexts. It creates quite an array of different parties that can be involved. But the important thing is that because of this multi-layered interrelationship or web of human interaction, there is one party who, because of that party's own interest, may not be able to meet the interests of the other party. The concept really has become a term of art, but it sheds great light on the importance of knowing when we find conflicts of interest or when they exist in order to be able to do something about them, but at least to be aware of them and how they could prejudice somebody's interest and somebody's actions. So let's consider a couple of other scenarios here. Let's say I work on a sales team with 3 members. We always have worked on prospects together and we've split our sales commissions. It's really helped each of us on the team maintain kind of a consistent practice. It helps us ensure that we've got a constant revenue and we actually pool our resources, including our intellectual capital, to bring the best sales effort to our clients. Now, I make a contact at a dinner party where I am alone, not with my business colleagues. And this person's interested in what would be the largest sale in our company's history. A second scenario to consider. My elderly mother has a rental property and cannot manage it anymore. She asks me to manage it for her, to take what I think is a reasonable fee because she doesn't want to deal with this and she doesn't want to get involved with, upsetting my siblings, and then split the remaining revenue evenly between me and my brother. So she gives me the full responsibility to do this. My interest in each of these extends to myself, but to others. And the question becomes, what should I do? There are implications, obviously, to what I do. In the first instance, with my sales team, if I decide to pursue this contact on my own, I will be breaching an agreement with my fellow work colleagues. Now, that may not be a legal agreement. They may not be legally entitled to this, but we've always had that understanding on how we've worked. And my determination here will breach the reputation of good faith that we've operated under. In the second instance, my actions here, because my mother's given me full discretion, will potentially have a negative impact on my relationship with my brother. So in these two instances, we see how decisions made when presented with these scenarios can impact the future. They can impact reputation, they can destroy relationships, and these are extremely important things, as we know, in business and in life. So a couple of takeaways that I think are important. Decisions matter. What we decide today will have implications for the future. And when conflicts of interest are involved, it's important to try to identify those when they're occurring so that we don't create situations that we regret later and that become very difficult to reverse. If I were to decide in the first instance that I wanted to pursue this on my own because it's the largest possible sale in the company's history, that would breach the trust of my team members, and I would assume that they would not want to work with me any longer. They might consider that I've basically become a traitor to them. And likewise, if I take advantage of the faith and trust my mother's placed in me to my advantage, but to the disadvantage of my brother, I would destroy that relationship with my brother. And that's a familial relationship, a family member that, through this arguably business transaction would have implications. So as we look at the definitions, here, conflicts of interest, those three words really entail so much meaning and so much implication implication to what may be based on decisions made, based on facts and circumstances. And so that leads us to look at, key parties. Conflicts which arise in a business context may arise among a company, its directors, its subsidiaries, its employees, its clients, and its third-party vendors. That's quite a mouthful, and it's intended to convey the sense that almost anybody in the business context, in the chain of business relationships, can be involved in a conflict and can create and raise a conflict based on that person. Common examples I'd point to in the corporate setting would be affiliate to affiliate. So if you have a large corporation with multiple affiliates, depending on the structure of the large corporation and how it operates, it could, for example, create a rivalry, if you will, between affiliates. They now have a differing interest. One has to be more successful than the other based on the directive that's sent down from the main corporation. You could have an affiliate to a client. So it's always the nature, and we'll talk a little more about this coming up, the nature of business relationships that maximizing income and maximizing sales are important drivers. Well, they may result in taking actions that are adverse to the client's interest. In the normal commercial relationship, we would say it's up to individuals to negotiate, right? If I go to the market and the vendor in stand A wants to charge me $2 for an apple, but the vendor in stand B charges $1, it's my decision of whether to pay the 2 or to look for the 1. And so, it's implicit on me. But as we'll talk about later, there may be circumstances, situations, characteristics of the client that will have to be taken into account because it could put them at a disadvantage and result in the reputational relationship and other risks that we talked about. Company to client, very similar to affiliate to client, except this is the corporation at the main level, where there could be a conflict with the client across the board. Again, if a large company has multiple affiliates and each of those affiliates is providing services to a similar client, they may result in disadvantages to the client, depending on decisions made and the structures that are employed and the policies employed by that main company. Employees also can have conflicts, an employee to an affiliate. A situation where an employee could misuse information, for example, they come across in the course of their employment. They use it to their own advantage. That would be a conflict of interest. Depending on the business, it could also be a legal issue. And then employee to client, the same type of structure here, where the employee may have some sort of interest that could be putting themselves ahead of the client interest. And then finally, affiliates to third-party vendors. This brings in the notion of a vendor to a company that the company does business with. The company itself may try to take advantage of the vendor, or the employees could also do the same thing, agreeing, for example, to give the vendor business if they give the employee some personal benefits. So the intent here really is to illustrate that these are some common parties in conflict type arrangements, but it really can extend to anybody. The determination of the actual conflict requires looking at the individuals, and by individuals I also mean legal entities, as well as the facts and circumstances surrounding their relationship and their obligations to each other. I always think about conflicts in terms of action. So there's some sort of actionable element that brings these entities together, but that depending on how actions are decided could create a conflict between them. Now, having talked about these various parties, we can talk also about certain characteristics of relationships that could contribute to the existence and the extent of conflicts of interest. The nature of the relationship, which I've just referred to. There may be relationships, for example, that are by their nature and by their designation called fiduciary relationships or relationships of trust. There could be relationships that have contractual responsibilities, where the parties have agreed, we have a responsibility to each other. And then, there are also, as I pointed out earlier, probably less of concern to us, but still potential concern in the business context, actual familial relationships, brothers, sisters, working together, that can create its own type of conflicts. And then relationships of commerce and of reputation, relationships that are based on reputation. Another key characteristic is often tied to determinations of value, where there's a price or an exchange value or a tax benefit, some sort of tangible currency benefit. There can be a conflict of interest. if there's a discussion or a determination of price, of exchange value, of tax benefit, and there's not necessarily an independent way to establish that, then one party, based on the nature of the relationship and some of these other factors, could put themselves in a better position based on those factors. A key area that undoubtedly creates the risk of conflicts of interest are opportunities for personal gain, especially where there are monetary benefits or career advancement. Prime examples on the monetary benefit side would be sales roles where you're compensated on commission. In those cases, sealing the deal, getting the largest deal possible, etc., would be a benefit that could incentivize somebody to act against the interest of the other party. Professional advancement is another one. Making yourself look good to your boss. And there have been documented instances where people have inflated numbers, or we'll talk about a circumstance in the Enron case where the accounting practices ended up making different parties look good, and therefore can be seen as contributing to, if not being the cause of, the problems that ensued. Another important area for consideration here is the lack of parity in the horizon of interests between the parties. So lack of parity is intended to capture the notion that one party has, this is the horizon of interest. So one party may not have an interest in as long of an exposure. So, an example would be we'll talk about this in the financial crisis, where a bank may start a loan but sells it off. They don't have any long-term exposure to the loan, and the problem will be somebody else's. So their goal is just to, get the deal done and then sell off the exposure, and then it becomes somebody else's problem. Because they don't have a long horizon view of things, their behavior could be incentivized differently than if they actually did. And then finally, what I started to say earlier, lack of parity in the power or sophistication of the parties. A classic example in the non-business sense would be an adult dealing with a child. The adult, of course, will carry more gravitas, more sense of responsibility, and the child will in all likelihood defer to the adult. Well, we can extrapolate that, in a business context where a large company is dealing with a small, client, and the client can't really negotiate the terms. The company may make them think they can, but they really can't. When we buy our iPhones, for example, and we go to the Apple store, we are signing contracts. None of us can negotiate those contracts. In the law, there's this concept called contracts of adhesion, where the effective negotiating power of the party who is signing doesn't exist, and the law acknowledges that. So lack of parity, as described here, can be a factor also in conflicts of interest type situations. Now, all of these parties and common characteristics really point to the fact that there are common relationships with inherent conflicts of interest. Inherent conflicts, conveys the notion that these conflicts exist just by nature of the relationship. A couple of examples here we can talk about. Financial advisors. The financial advisor is incentivized to make as much money as possible. And sometimes that could involve selling more products than are really needed based on the client's goals. There may be other drivers depending on the compensation agreements with clients. Lawyers have that relationship. Lawyers will frequently be in positions where they are holding money on behalf of a client. There's the possibility and the potential that they could misuse that money. If, for example, the money were being held for a real estate purchase, the bank, who is financing the transaction, gives the money to the lawyer needs it the day before the transaction, and then the client is going to close on the real estate transaction the day after. The lawyer's holding that money overnight. Well, if the lawyer doesn't manage his or her own finances very well, or that of those of his or her firm, the lawyer could, in theory, use that on a short-term basis. Well, that, of course, can have trickle-down effects and could impact clients adversely. So that's just one example in the case of lawyers. But they're in that position where trust is essential, and so the conflict is inherent in these relationships, given that they could always act in their own best interest over that of their client. Real estate agents, another common example. It's not always clear for whom the real estate agent represents. In some cases, and in some states in the United States, it's permissible for a real estate agent to represent both the buyer and the seller. That would create, obviously, a very difficult situation if there were problems with the real estate transaction. Going back to the definition of conflicts of interest, how could the real estate agent possibly act in the best interest of both sides if they're trying to resolve the situation? Real estate appraisers, they're fed business by mortgage companies. Mortgage companies, at least historically, have wanted them to just process the information they're given. So they're in that position where they have an inherent conflicts of interest. The executives of publicly traded companies, who are frequently paid in shares of those companies, have an interest in ensuring that the public financial perception of the company's financial health is positive, so that the share price stays up. And then finally, accountants, can also be in this circumstance. And we'll talk about the Enron case and the role of accountants, but suffice it to say, accountants are hired by companies, and because they're hired by them, there is always the possibility that they may feel pressure to give good results so that they continue to be hired by that company. These are just a few examples of common relationships with inherent conflicts. You can see and extract from this, though, that there are some industries themselves that are frequently and probably inherently conflicted. Financial services is clearly one. Pharmaceutical companies, also another one, where developing drugs, bringing drugs to market as soon as possible, charging as much as they can, and then incentivizing where they can medical professionals to use their drugs. All of that creates, many opportunities for conflicts of interest. And then one that has been notable in the United States in the last decade or so has been educational institutions. We wouldn't expect that educational institutions themselves would be subject to conflicts, but with Title IX requirements pertaining to allegations of sexual misconduct by students, it's been demonstrated that universities, have an interest in ensuring that things do not make the news, right? That their reputations remain intact. And so that could put them in a position of not taking certain actions that could otherwise be beneficial to the parties involved, because it's better for the institution. So we can extract from all of these parties, characteristics, relationships, and industries, several notions, that I think apply across the board, and certainly in many of these cases lead to regulation that is intended to address some of these conflicts, and regulators that are empowered to address them. It doesn't exist, though, in all cases, so that we cannot always rely on regulation. And quite frankly, regulation frequently takes time to catch up with actual problems. So the classic situation is one where problems have occurred, regulation is adopted to curb those problems, but the regulation may not prevent the problems of the future from happening. So with this background, I'd like to move on to just do a couple of case studies. The first one is the Enron situation. Many of you may recall Enron. It was formed in the early 1990s and it operated in the fairly lightly regulated energy industry as an energy trader and supplier. It grew fairly quickly though, and as it grew, it benefited from soaring stock levels experienced more broadly in the markets at the end of the 1990s when we had the tech bubble. At that point, the historic notion of valuations based on earnings and earnings per share, these classic criteria that were used to determine stock levels seemed to be thrown out the door. And it became no longer a question of what have you earned and what have you shown the potential to earn, but more what is the best case scenario that you could possibly earn many years down the road. So again, Enron benefited from this. Now, it's alleged to have inflated the value of many of its assets through accounting practices and to have hid the extent of its debt through off-balance sheet vehicles. As a result of this, its stock price hit a high of nearly $90 a share in mid-September of 2000. But 14 or 15 months later, by December of 2001, it was trading at around 25 cents per share following its bankruptcy filing. So these facts, really raise questions about multiple responsible parties here. The board of directors of the corporation, the executives of the corporation and its various subsidiaries, the lawyers for the company, the accountants for the company, the auditors for the company. And there are probably a whole host of others. As we assess these facts, though, and looking at each of these persons, conflicts of interest become clear. I will not go so far as to say that conflicts caused the problems, but it is fair to say that conflicts were certainly agreed upon to have contributed significantly to the problems. With regard to the board, clearly the stock price, as I mentioned earlier, for both board members and executives is an important indicator of success. So when the board sees the stock price doing well, obviously it's happy, just as the executives are happy. But the board really should be exercising oversight over the executives and not letting the executives, run the show without some sort of independent validation. So, there's the possibility here and likelihood that the board failed in its oversight responsibilities. Now, the board has a fiduciary duty to its shareholders. And one of the open questions to me is how the board, managed all of this, given the extent of, what had occurred, by way of accounting practices and by way of its extent, the extent to which it had debt obligations. Perhaps that can be tied to the executives. Did the executives give the board all of the information it should have? The board, does not and is not responsible for management. Does that create, though, the possibility of conflicts of interest? If the board is chummy with its executives, they're all friends, they operate in the same social circles, does that not create conflicts of interest in terms of personal relationships that end up impairing the board's ability to act appropriately and in the best interest of its shareholders? Lawyers are involved. I mean, clearly lawyers have been involved, and in most corporate settings I've been in are always involved when it comes to assessing practices, especially when it comes to not necessarily accounting, but how the company handles its subsidiary operations, the responsibilities of subsidiaries for debt and other things like it. So here, lawyers had to have been playing a prominent role. We must ask again, did the lawyer or lawyers involved have clouded judgment because they had been making so much money from this firm? They knew the people, they were no longer questioning as independently as they should have. The same can be said for accountants and for auditors. When you look at these practices, the accounting practices may have had a basis in law, or at least have had an argument, but the way the company really fell and how quickly it fell suggests that there was an inappropriate accounting practice, or at least it was not made known to the board what these practices entailed, because once they came to the fore, the off-balance sheet debt, what people thought was not company responsibility, was determined to have effectively brought the company down. So I think Enron's a case study in bad corporate management, with various parties who should have been playing balancing and challenging functions, failing to do so effectively. Again, I can't say definitively, but it does seem that conflicts of interest, certainly played a role here in hindsight. And I would point to the fact that the lack of regulation in the industry probably, was an important factor. It should be noted that one of the outcomes of Enron in the United States was the adoption of the Sarbanes-Oxley Act. And that act really was intended to do several things: make accountants and auditors much more responsible, and also put a system of controls in place that all companies had to follow to be sure that these sorts of things didn't happen again. The second case study is less about a company and more about general real estate practices and the banking practices that supported them in the 2000s. Lowest interest rates through most of the 2000s resulted in a robust real estate market for both sale of homes and refinancing of existing homes. And this was global. This was not just in the United States, as I'm sure many of you know. There was a practice here, though, where collateralized debt obligations allowed banks and mortgage brokers to make loans to individuals, to package those loans in groups, and then to resell them through banks to the CDOs, collateralized debt obligations, thus taking them off the bank's balance sheet. Now, here I'm going to pause and recall the notion I had put forth earlier of one characteristic of conflicts being this lack of long-term exposure. The banks here were trying to get the items packaged and sold. So they became almost, CDO production machines. And that turned out to be a problem. Now, rating agencies rated these CDOs, ensuring that there was a secondary trading market, including for subprime mortgages. And then in the mid-2000s, the SEC lowered the capital reserve requirements of investment banks who were actually packaging these CDOs. So a sequence of events, none of which necessarily, would be said to have caused this, but which collectively certainly led to, the worst banking crisis we've seen since the Great Depression. Now, once rates started to rise as the property market slowed, a global crisis ensued. And the result was a seizing up of the CDO market and the failure of many global institutions. This situation is notorious. I won't go into great detail because I'm sure most of you understand what went on and the institutions that failed. The bottom line, though, is a whole series of additional parties are involved here. that did not have any involvement in the prior example. Regulators. This was a highly regulated industry. The real estate industry, had its share of problems over the years. The savings and loan crisis in the United States in the 1980s involved real estate. Practices changed at that point. There was another dip in real estate in the 1990s, and then here we are back in the 2000s dealing with the same issue. So regulators who have a responsibility for identifying from a policy standpoint where regulation should exist, arguably in hindsight, didn't do as much. Lawyers, the same thing. CDOs were creations by lawyers, probably at the behest of business people, but still lawyers playing a role in it, and lawyers trying to create what are considered bankruptcy remote companies, so that these companies exist on their own and they don't impact or impair the banks. Accountants and auditors, again, both involved here. These companies ended up with these contingent exposures that ended up creating a great financial pressure on them. Rating agencies involved here, as well as regular banks and investment banks. So a whole slew of new players, if you will, each with, except for regulators, with a financial stake in all of this, right? The lawyers were making boatloads of money because every time these CDOs were, required to be created, we had to hire lawyers. Accountants needed, to manage the accounting, for this huge influx of loans, and then the selling off of those loans to these entities. Auditors involved in auditing all the institutions involved, including those that ended up failing. And then importantly here, rating agencies. One would think that rating agencies would not really have a conflict. I think that was the notion going into the crisis. But it soon became clear that the rating agencies were churning out ratings almost on a without much thought or without much consideration for the underlyings of each of these instruments. They became incentivized, like the lawyers and the accountants, because they received continuous flows of money from the CDO operations. So once again, new players involved, but the same scenarios effectively coming to the fore. Go back to the comment I made at the beginning. This often entails economy, psychology, and human behavior broadly. We see all of these coming together in actions taken or not taken by the various parties here that can be attributed to conflicts that existed for them. They were acting in their own interest, above and beyond the interest of the other parties that they had an obligation to. Mitigations are essential and critical to dealing with conflicts of interest. Because they're inherent in most business arrangements and they're nearly impossible to eliminate, but they can be mitigated. Common mitigations include, as I mentioned earlier, regulation. And part of regulation is not just having the law on the books, but creating a very powerful regulatory agency that can enforce those laws. If you don't have a regulatory agency enforcing laws, the regulation, almost only becomes valuable in a lawsuit after there's a problem. So regulation and powerful regulatory agencies, I think, are two critical components of mitigation. Disclosure is another one. And this is a pretty fundamental element of conflicts of interest as it has been incorporated into regulation. And that is requiring identification and disclosure of conflicts. This really forces people and institutions to ask themselves where conflicts exist and to try to identify them proactively. This is an area that in my job, I have some pretty specific experience with, I'm always trying to get disclosure to be owned by business people. They would prefer to say somebody else can tell me where these conflicts are. I don't understand conflicts of interest, but my goal is always to say, you need to understand them because you own them and you own the risk of them. Disclosure is one way to try to force that down, make them think about it in order to have it as part of our corporate culture. Independent auditors. This is another area where common mitigation can be seen. Now, independent auditors is an interesting notion, given that the auditors were involved in both of the two scenarios I mentioned. Some European countries have adopted regulations that require that auditors actually rotate. So an audit firm can only be on an engagement for a fixed amount of time. And that requires the company to go to another audit firm. There's a feeling there that that will prevent the complacency of auditors from happening, because they know that they only have a fixed time frame, and they need to do what's right during that time frame, because if they fail to do so, the new audit firm will pick up on it and it would become probably newsworthy. And then finally, this notion of legislated legal recourse through clear causes of action. That gives individuals who may be impacted by these conflicts a right to sue. I don't consider that personally to be one of the strongest mitigants, because it is only available typically when there is actual harm. But if all else fails, then the threat of that harm and the suit that could result from it can serve as a mitigant against future actions by other parties. So to conclude, a couple of comments. First, while conflicts of interest may be inherent in many business and commercial relationships, I believe they need to be identified and appropriately mitigated. And why that is important is, because of the clear truth that failure to do so can have severe and often irreversible consequences to a company, its executives, its employees, its shareholders, and the broader economy. This was experienced in the many financial crises we've seen during the 20th and 21st centuries. In addition to noting that the conflicts should be identified, it's important to understand that where these conflicts have resulted in significant legislative and/or regulatory changes, compliance programs really have become essential tools that have shown themselves to be pretty effective. Now, compliance programs are based on several key components, which will help here. So one is having policies and procedures. So to the extent there are regulations and/or to the extent there are policy decisions to be made by an organization, they can be captured in policies and procedures. Secondly, identification of conflicts of interest. Typically in policies and procedures, we would seek to identify conflicts. And third, we would have a risk assessment in which conflicts would also be identified. And importantly, the controls that we have to mitigate against the conflicts would be articulated. In a compliance program, we will test for the effectiveness of all of these items, and we will train people to be sure that there is this broad understanding as much as we're able to across the firm and all levels of the firm. So the bottom line is all of this comes back to the traditional notion of trusting but verifying, and compliance programs are certainly important tools for doing this in the context of conflicts of interest. Thank you very much for your attention, and I am happy to take any questions.
Thank you, Professor Hogan. It was a very nice presentation. I noticed one case that we deal here constantly, which is the independent auditor, because as a university, we're required to go through external audit by independent auditor, and I always found that a very awkward situation, in a sense that we as a company, it's up to us to choose what auditor we're gonna use, and we pay the auditor, and they have to audit us. So I see the sense that in their case, they cannot be, they want the business, of course, but they also have this, they're compromised with the government because they have to provide a sound audit, right? So it's a very, very interesting situation, right?
Yes. It is, like I said, some European countries, and I'm sure others, have tried to address that by limiting the number of years and as one audit firm can be used. But that has not, to my knowledge, become the norm. So, we are in a situation where it does create awkwardness.
Yeah.
I see it myself in our dealings.
Yeah, interesting. So I have some questions here from the audience. One was, I'm an investment advisor that earns a commission when my client puts money into a fund, let's say Fund A. How do you see if I recommend to my client to switch from a Fund B to A, considering that the funds are very similar in terms of risk and returns, but Fund B doesn't pay me any commission?
That is a classic question that I think we all have to deal with in the industry. So I will give you my personal answer, but I will caveat the personal answer with the regulatory reality. My personal answer is, if you're providing a service and you are open with your clients about that service, the fees you charge, and the revenue you get from it, I would say that that is an acceptable alternative, as long as you can demonstrate that it is a fund that is in the best interest of your client. And based on the question, it sounds like that's the case. That's my personal opinion. I think the reality is regulators around the world are beginning to question that type of decision making. So it requires, very careful consideration, and I think a taking of the temperature in the environment, in the specific jurisdiction or locale in which you're operating. So I wouldn't say, point blank, it's acceptable. You can do it. I think there are very strong arguments for it, and I think the reality is that happens all the time. But I do think it's on regulatory radar screens, and so we have to be careful, and we have to monitor what regulations are coming out and how regulators are addressing that type of conflict. But again, disclose. The best defense to the conflict of interest is to disclose clearly and prominently and openly to clients.
Okay, great. Yeah. And what would be your recommendation to deal with conflict of interest when two companies that share one common shareholder are starting a joint venture? Consider that the common shareholder is a minor shareholder in one and a major shareholder in the other company.
So I would answer that by saying, as a general rule, I would need more information really to analyze it. I say that because there are, in addition to the conflicts of interest involved, there may be laws that are applicable here and that would be very important to understand based on minority shareholder rights and majority shareholder rights. There are also, potential, I don't think there are laws necessarily, but, you want to be sure that this notion of interlocking directorates, directorships, et cetera, is worked out. But generally speaking, if these are, what we would call institutional investors, so investors who, do this as a job, and not, individuals who maybe don't do this as frequently, then there's less risk in doing it. But again, I'd want to understand where this was happening, what the laws of that jurisdiction are, especially with regard to minority shareholder rights, because that could create a really messy situation. But again, I'm sure this is something that happens all the time. And so, I don't think there's a prohibition against it. It becomes more a question of commercial prudence on how to address it.
I see. Very, very interesting. And how do you see the situation where a top executive of a company has a side business? Should this type of executive be prohibited of having outside businesses or offering independent consulting services, in your opinion?
Well, I will answer that question by framing it as a question of whether there is a conflict. So the question really is, does that business opportunity conflict with the business the chief executive runs? So for example, if the chief executive is the chief executive of a financial services company, and they determine that they want to start their own financial services company, well, that would create a conflict of interest, right? If they were competing in the same business, they'd be going after the same clients. So if that were the case, I would say that that should be prohibited. If it were a totally different business, though, so let's say the chief executive is a chief executive of a financial services company, but his spouse wants to start an art gallery, and it's a specialty art gallery, that really appeals to very wealthy clientele. There may not be a conflict there, so that may be totally acceptable. There are many circumstances like this that have been found over time where improprieties were found. So I think the basic advice there in those circumstances is always proceed with caution, but be sure these are disclosed, and most importantly, disclosed. If this is CEO of a company, disclosed to that company's board. They need to be aware and basically approve of it. If they don't, then then I think that the chief executive should not proceed.
Okay. And how do you see when the same consulting firm serves competitors, in a sense that they can use successful insights from one competitor and apply to the other?
That's a difficult question to answer because on the one hand, I think many of us use consulting firms because they have that information. Now, in my experience, the consulting firms I've dealt with have been very careful about sharing information. They need to reflect, basically their client contracts, right, and their agreements with clients on what information they could share. I think this has become certainly much more of an issue because of the attention paid now to privacy laws. And this is, again, worldwide. Everybody focuses on privacy, and to the extent they would be sharing any personal information or private information, that would be that would not be permissible today. However, if they're sharing general market information, general industry information, and not revealing corporate secrets, I think, again, that's why we like to go to consulting firms. They have that information. They can provide benchmarking without getting specific, and they can help us with our businesses. There are many instances though, where that would be a conflict, and I think audit firms and law firms have addressed this in their practices. Law firms, for example, will not take on a client in a practice area if it would represent a major conflict with other clients. I know that for a fact. Now, there's a threshold that has to be met there. They must agree that the conflict would rise to a certain level of materiality before they get there, but there are controls there.
Okay, great. So now I would like to open to one of our graduates, Pedro Andrade. He completed a Master's of Science in Legal Studies here, and he also completed his bachelor's here. And he has a question, I believe. Go ahead, Pedro. Welcome.
Yes. First of all, nice to meet you, Professor Hogan.
Nice to meet you, Pedro.
I was actually anxious to hear you here today. I have actually two questions. First of them is about the case you talked to us about the subprime case in 2008. The question is, how can actually the agents, the rating agents, really be, how can I say, really do an independent evaluation, considering that they are paid by the banks that are the most interested parts in having the major level in these evaluations. How can I, being a owner of a rating agents, sell my service if I do not some way analyze this as a AAA, for example? That's the first question. And the second question is the same line, but about the universities. When, for example, some bank hires Harvard or Columbia to do some diagnosis and are paying them for saying that that bank is acting correctly. And these two questions, I really don't know how to solve these problems.
Thank you, Pedro. Great questions. And I'm not sure, there's any clear-cut answer. With regard to the subprime, I would say, first of all, I agree with you. It's challenging to consider how the rating agencies could act independently because they're paid by the banks that hire them. The problem there, though, is every example of a service provided would be subject to that same type of analysis. If I go to the, but I would say it this way: if the nature of the relationship works properly, it's great. If it doesn't work, then it isn't. And I will use the personal example of, I go to a doctor, I have to pay the doctor, but the doctor isn't being paid to make me think everything is okay, right? That the doctor wouldn't be meeting the doctor's professional obligation there. But the doctor also would suffer reputational risk, right? If I had cancer and the doctor failed to diagnose my cancer, then I go to another doctor as I'm about to die, and they say, "Oh, well, you've had cancer for 10 years." And I said, "But I went to the doctor and he didn't, if that first doctor didn't, act properly, he or she would suffer that reputational risk." You would think the subprime mortgage agencies would have felt the same way. Clearly, they didn't. Now, one difference between the doctor and the subprime agency, at least back then, was that the subprime agencies really didn't have any obligation. Like, they didn't have a regulator or a code of ethics that said, you ought to do the following. They considered it like, I don't know, just a process, right? It was a process. It was a way for them to make money. They had general standards behind it, but people learned how to work with the standards, right? And in the subprime case, and I'm probably going well beyond your question here, but it's my understanding in the subprime case that the rating agencies became comfortable with a numeric formula that said, let's say you have 3 levels of subprime, A, B, and C. A being, just like it could have been, it was just below investment grade. B being, it's a little worse, and then C being the absolute worst. Their formula would say, as long as you had only, pick the number, 20% exposure in the C's then numerically, and based on statistics and all these other things that I'm not an expert in, this would be acceptable risk. The classic black swan, right? It could happen. It hasn't happened in 100 years, therefore we think it won't happen. Where really what we should be thinking is, if it hasn't happened in 100 years, it's more likely to happen now. So I agree with you. I think a lot of this has now taken, or a lot of that analysis now has factored in to put more pressure on these rating agencies, but it remains to be seen whether it will be effective. In terms of the second question, again, I think this is a classic conflict of interest, and this is one that I don't think has been addressed. A great example, and I'm writing a paper for a different purpose on this, and I cite this case where in a lawsuit you bring in expert witnesses. Well, they're paid to tell a certain side of the story, right? Both parties have expert witnesses, and both parties have witnesses who support their side. It almost gets to the point where you think, well, it's absurd to rely on expert witnesses, because you can basically pay somebody to give you your opinion. I don't think we've really dealt with that, very well yet in the world. And certainly in the academic circles, there are plenty of instances of this type of question coming up. I think there were, I forget the university, if it was Harvard or MIT, but where a certain doctor or academician's research was found not really to have been as thorough as it was reported. Conflicts of interest all over the place, So I think that's an area that probably is ripe for more reform, whereas subprime, and the rating agencies, because of the problem we've had, is a little further along in terms of being addressed. I hope that answers your question. Questions.
Thank you.
Yeah, and I see this case of the witness that you said. I think it applies also to legal opinions, right? That you can hire an attorney, and you shop around and see who is willing to write this legal opinion that support my side, right?
Yeah,
so
exactly. I do this at work. I am, because I'm not technically on the legal side, I'm on the compliance side. I will challenge the lawyers. And I don't think they like it, but I'm not paying you to tell you what I want to hear. I'm paying you for you to give me, unabashed, unvarnished advice. Then I can make my decisions. But if you just pay me, or because I'm paying you, you listen to what you think I want and then you give it back to me, that does not help me in the long run.
Makes sense. Yeah, that's great. All right, so Michael, I think that's it. I really appreciate your presentation. It was very informative. I really liked it. As always, it's a pleasure meeting you. And Pedro, thank you for your participation, and thank you for everybody who watched us tonight and who submitted questions. And that's it.
Great.
Thank you very much. Have a nice evening.
Have a good evening.
Bye-bye.